The statement, Bare Act Article 4, laws made under Articles 2 and 3 to provide for the amendment of the first and the fourth schedules, and supplemental, incidental, and consequential matters. 1. Any law referred to in Article 2 or Article 3 shall contain such provisions for the amendment of the first schedule and the fourth schedule, as may be necessary to give effect to the provisions of the law, and may also contain such supplemental, incidental, and consequential provisions, including provisions as to representation in Parliament and in the legislature or legislatures of the state or states affected by such law, as Parliament may deem necessary. 2. No such law as aforesaid shall be deemed to be an amendment of this Constitution for the purposes of Article 368. The simplification, explanation, the simple majority power, the ultimate prelims fact. Clause 2 contains the most critical takeaway for exams. It explicitly states that when Parliament creates a new state, Article 2, or alters an existing state, Article 3, it does not need a complex constitutional amendment under Article 368. A simple ordinary law passed by a simple majority, more than 50% of members present and voting, is completely sufficient. Automatic schedule. Updates. When Parliament changes India's internal boundaries, it triggers a domino effect. Article 4 ensures that Parliament can automatically update the first schedule, the official list of states and UTS, and the fourth schedule, the allocation of Rajya Sabha seats to each state, within that same ordinary law. Handling the domino effect. The phrases supplemental, incidental, and consequential give Parliament total power to manage the structural fallout of making a new state. This includes rewriting laws, setting up a new High Court, shifting administrative officers, or calculating how many MLA and MP seats the newly formed territory receives. The context, landmark case, and real-world example. The landmark case, Berubari Union Case, 1960. Can Parliament use the simple majority power of Article 3 and 4 to give away Indian territory to a foreign country? This exact question arose when the Indian government tried to cede the Berubari Union territory to Pakistan. The Supreme Court ruled with a strict no. The court declared that Article 3 and Article 4 only apply to internal reorganization among Indian states. If Parliament wants to cede sovereign Indian territory to a foreign nation, Article 4 cannot help. It absolutely requires a formal constitutional amendment passed under Article 368. The real-world example. Jammu and Kashmir Reorganisation Act, 2019. When the central government decided to restructure Jammu and Kashmir into two distinct union territories, J&K and Ladakh, they utilized the mechanics of Article 3 and Article 4. Parliament passed an ordinary bill. Under the authority of Article 4, that single bill automatically amended the first schedule to remove J&K from the list of states and add it to the list of UTs. Simultaneously, it edited the fourth schedule to adjust how its 4 seats in the Rajya Sabha were handled, seamlessly managing all consequential administrative shifts without ever touching the rigorous Article 368 process.